Hello guys, this is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we are talking about the evolution of the doctrine of privity of contract. In my last class, I talked about the introduction to the doctrine of privity, and while I was introducing, I told you about the third party right and how to raise the preliminary objection in court. That's the essence of the defense, to say that a party is only a third party to a contract and not a contracting party, and therefore a third party to a contract, also known as a jus quasitum tertio, or also known as a stranger to a contract, cannot reap the benefits of that contract, right? So therefore, you will tell the court to strike out the case because the party is not a contracting party and therefore cannot reap the benefit of the contract. That was what I taught in my last class. But in this class today, we are talking about the evolution of the doctrine. The last class was merely to introduce you to the doctrine. Now we are talking about the evolution of the doctrine, and we are going to be discussing two important cases. We are discussing the case of Price and Easton. Also, we are discussing the case of Tweedle and Atkinson. Now, before we go straight into what we have today, if this is your first time of coming to my channel, then I want to say a very big welcome. Please make sure that you click the subscribe button and make sure that you click the notification bell so that anytime I release a video of this nature, which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, please don't forget to share with your friends and colleagues and other people that you know will be in need of this particular lecture video. Lastly, please don't forget to follow me on Instagram and on LinkedIn at Diekolola Daniels on LinkedIn and Dieko_Daniels on Instagram. Thank you so much as you do so. So now, while we are going into the crux of what we have today, before I get into the lecture itself, there are certain things that I need you to understand. When you are reading a case, there are three things that are key to that particular case. What are those three things? The first thing, what is the fact of the case? The second thing, what is the issue that has been raised by the fact? And the third thing, what is the judgment of the court? You should know that when you are reading cases, these are the three things that you should seek, you should go to identify. Do you understand? You should seek to identify. Now, also, extremely importantly, you should also understand that for every rule that you are giving, there has to be what? There has to be cases. You know, in my last class, I didn't cite any case. You cannot carry the knowledge of my last class and enter exam hall and tell the lecturer, I understand privity now. Privity is also known as this, is also known as that, blah, blah, blah. You did not cite any case. You will get zero. That is, there's no big deal. Your zero will be big. It will be fantastic. You know, you don't go into the exam hall knowing the principle, but not knowing the cases attached to the principle. No. That's a very wrong way of reading law. So what do? When you have known the principle, which is what I started with, then you now go to the cases. Then you now show how does this case apply to our principle. And while you are showing that, you have to, what is the fact of the case? What are the issues in the case? And how did the court decide on this issue? So while we are talking about the first case today, which is the case of Price and Easton, the first thing is, what is the fact? Now, the fact is that a declaration between the parties stated that X owed the plaintiff £3. As such, X agreed to complete work for the defendant in exchange for payment, which would clear the debt that he owed to the plaintiff. The defendant agreed he will pay the plaintiff on X's behalf once the work was finished. X completed the work for the defendant, but the defendant did not pay the plaintiff or X as had been promised. The plaintiff sued the defendant for the money that X owed him, which would have been paid by way of the defendant's payment. Now, I'm sure that we are already confused here. let us break it down a little. Now you know that we are all in the university and all that. Sakpa has not hold boys yet. You know when Sakpa hold you, from beginning of a semester, we are all chilling and gisting. Everybody is, let us go and buy Corridor Spark if you're in the lag. Let us go and buy Corridor Spark today, tomorrow. I feel like taking Mavis rice. No, I don't. I want to take Mavis rice. Then another day, I want to eat Iamoria. Oh no. Those kind of things. Then that's the beginning of the semester. Week 1, week 2, week 3, week 4, you are still flexing. Then week 5, week 6, week 7, you don't know, say you don't dey hold you understand? So you that used to take Iamoria, Corridor Spark, now you are not eating bread and beans from 2001 at New Hall and all that, and now from bread and beans you are now taking Gary. From Gary you are now begging. You get what I'm saying? So you can see the depreciating factor. Now this is the thing. So let us say that we have Sheyi. Sheyi is a student of Unilag, and during that time when Sakpa had hold Sheyi, like tick Sakpa, then Sheyi now said, okay, what do I do? Sheyi now went to borrow money. Are you listening to me? Sheyi now went to borrow money from Dele. Now, when Sheyi borrowed money from Dele, he said 1 week my parents will give me the money, blah 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 blah. Let's say there is a contract between Sheyi and Dele. Then Dele gave Sheyi how much? Let's say he gave him 3k. In this case, it was how much? £3, right? So, but in our case, it was 3,000 naira, right? Okay. Then after the 1 week had passed, 2 weeks had passed, 3 weeks had passed, and then Dele was like, Sheyi, he went to Sheyi's room one morning. I said, yeah, my money, fast. And then Sheyi said, I no get. That kind of levels. Don't worry, I will get it for you. When he saw that his parents, maybe things were tight for his parents at that point, wasn't responding, then Sheyi now went to one rich guy, somebody that used to, ball, and this one is not a baller one day, mechanic another day. No, this one is a certain baller. He went to baller. The name of the baller is who? Is Akin. Now, when Sheyi went to meet Akin and asked Akin for how much? 3k. Akin said, no problem. If you work for me, let's say type my assignment, do this, do that, go to class and write attendance, do all those things I'm supposed to be doing. If you work for me for the next 2 weeks by helping me do my assignment, do my online test, do my this, write my attendance and all those things, I am going to give you the 3k after that 1 week. Now, I want you to understand that there are 3 parties here now. We have Dele, we have Sheyi, and we have who? Akin. Now, you understand that is not a party to this particular transaction between Akin and Sheyi. Dele is not a party, right? Okay. Now, but then it was stated in the contract between Sheyi and Akin that Akin will give the 3k to Dele directly. Are you listening to me? Akin will give the 3k to who? To Dele. How? Directly. Right? And Sheyi was supposed to work for Akin, and Akin will give the 3k to Dele. But the question that we need to ask, in relation to this contract, who is furnishing the consideration? Who is making the offer? Who is making the acceptance? The offer and acceptance is between who? Is between Akin and Sheyi. Abi, in this new contract, is between Akin and Sheyi. Whatever Sheyi and Dele had is none of our business. This is the contract that we are talking about. Akin and Sheyi, right? Now, between Akin and Sheyi, Sheyi is the one furnishing consideration by what? By helping Akin with his assignment, by helping Akin with his online test, by helping Akin write attendance, by helping Akin do any other school things that are necessary, right? What is the consideration that Akin is furnishing? Akin will be the one to now pay the 3k, right? So the question is, who is Dele to this contract? Dele is nothing but a third party, or what? Or a stranger. Are you seeing it now? Very good. So now, what was the issue before the court? The court was required to establish whether the plaintiff had provided any consideration for the agreement. Look at that. That's who is the plaintiff here? The plaintiff is Dele. Dele is the one that went to court and told the court, my lord, he promised that he will give me the 3k when Sheyi is done. So now the question that the court will now say is that whether the plaintiff had provided any consideration, has Dele given any consideration for the agreement between Akin and Sheyi for the work that Sheyi had carried out? If this could be established, then the plaintiff Dele would be able to sue the defendants for the money that would have been paid to the plaintiff as a result, that's Dele, as a result of Sheyi's work to clear the debt that was owed from the separate agreements. Can you do you follow me now? Can you see how this is done? So now Dele has come to sue. The reason why it had to use Dele, Sheyi and Akin is because using plaintiff X and defendants might be confusing, and I want to bring it closer to home for you so that you can relate with the fact, because the more you relate with the fact, the better it is for you. So you can see that Dele is saying, give me my 3k, this guy. But the issue before the court is, can Dele say, give me the 3k? Is Dele a party to the contract, and that contract as between Akin and Sheyi? If Dele is a party, then we have to answer the question, did Dele furnish consideration? It is when we've answered that question that we can then determine whether or not Dele is a party. Dele did not furnish consideration. Dele did not make offer. Dele did not make acceptance. Therefore, Dele cannot be said to be a contracting party. Dele is only but a what? But a third party, known as what? Jus quasitum tertium, known as what? Third party or a stranger to a contract. Can you see that? So now, what was the judgment given by the court? It was found that X performed, Sheyi. It was found that X, Sheyi, performed his part of the agreement with the defendant. Who is the defendant? Akin the baller, right? But the plaintiff was a stranger. Dele is a stranger to the contract between the parties, and therefore could not sue for the sum by the defendant. Can you see that? This was despite the fact that the money owed, I want you to look at this part very well. This was despite the fact that the money owed would have been paid to the plaintiff to clear the previous debt. Now, the court found this on the basis that the plaintiff had not provided any consideration for the promise between the parties. The plaintiff's claim was dismissed by the court. There was a preliminary objection. My lord, we cannot hear this matter. Why? Because Dele, who is before those courts, had not furnished consideration for the contract. The contract was between who? Akin and Sheyi, and Dele is nothing but a third party. And since he's a third party, he does not have a standing. My lord, strike this case out. And the court had to look at, was there any consideration furnished? No. And because there was no consideration furnished, Dele is not a contracting party, and Dele cannot sue since he's not a contracting party. Do you understand? And then the case was struck out. And then let us look at this second case of Tweedle versus Atkinson. Very, very importantly. Now, in the case of Tweedle versus Atkinson, the son and daughter of the parties involved in the dispute were getting married. As such, the father of the groom and father of the bride entered into an agreement that they would both pay sums of money to the couple. The agreement expressly stipulated in writing that the husband should have the power to enforce the payment in the court of law. Unfortunately, the father of the bride died before he could pay to the couple, and the father of the son died before he could sue on the agreement between the parties. As a result of this, the groom brought an action against the executor of the will for the payment that was previously agreed between the fathers. Now, this is what we need to understand here. We are saying that there were two fathers. These two fathers is in relation to, bride and groom. One father for bride, one father for groom. Right? Very good. Now, what is going on here? There was a problem, and so the fathers now agreed between themselves. Now, these fathers, let's say it's Taju and Usman. Look at this. Taju and Usman. I want you to listen to me very well. Taju and Usman are the fathers of the bride and the groom. Now, Taju told Usman, these are our children that are always fighting because of money. You know what? Let us drop money for them. We are cuckoo rich. This money will help their family. Abi? No problem. So me, I'll drop 5 million. Okay, the other party said, no problem. Me, I'll drop 7 million. That makes it a total of 12 million. Abi? No problem. Then before Usman, who said he was going to drop 12 million, Taju said he was going to drop 5 million. Who made the offer? Taju to Usman, Abi? Who accepted? Usman. Who furnished consideration? The both of them. Furnishing how much? 12 million, 5 million, Abi? So it's the contract between Taju and Usman. But who is to benefit from it? It is now the husband, right? And it was clearly stated in the agreement that the husband can sue. Now, Taju and Usman, the contracting parties, they wrote it down that in the event that any of us fail to provide the money, that the husband has the right to sue. But before Usman could furnish his own 7 million, Usman died. So the next question everybody here should ask is, okay, Taju, sue Usman or his executors. Now, if you want to know who executors are, they are the ones that will carry out the terms of the will written by a deceased person. Deceased is someone who has died, right? So when the person dies, the person usually leaves a will, right? And when the person leaves that will, he cannot come from the dead, and come and execute his own will. So he will appoint somebody who is known as an administrator or who is known as an executor of the will to then carry out the terms of the will. So if someone does, I say, I give my house in Banana Island to A, I give my house to DISCUUSED to B, I give my house, do you get? It is not, those people in the will not go and start carrying the house. No, it is the executor of the will that will carry out the terms of the will. So those people are known as executors. So in the event that Usman dies, it is Taju, the other contracting party, that is now supposed to go and meet the executors of the Usman's will and say, look at our contract, me and him, before he died, he said he was going to drop 7 million. He has not dropped it. I want to get it from the will, right? Good. Now, before Taju could even do that, Taju now died. So 2 people died. Usman died, and that was before he was able to bring his 7 million. This other person that is supposed to sue, Taju, now died. So now the question is, okay, can the husband, who is supposed to be a beneficiary of the 7 million, he is not a contracting party, he is a third party that was named in the contract to have the power to sue, can the husband then sue the executors? Taju, who is supposed to sue the executors of Usman's estate, had died. He is the right party because he was a contracting party, but he has died. So now the question then becomes, can the husband sue? That's the issue in the case of Tweedle versus Atkinson. Now, the primary issue for the court was whether or not the son, that's the husband, could, as a third party to the agreement, enforce the contract between the fathers, which was ultimately for the benefit of him, the husband, and his wife. It was argued that the intention of the agreement between the father was for the couple to derive a benefit from the payment of the money. That's the essence. Moreover, it was argued that preventing the son from being able to enforce the transaction would effectively ignore the intention of the fathers. You know that the essence of contract law is for my intention to be carried out by the law. That's the essence. I want to contract to buy something. And if I buy it from you, contract law is supposed to make that contract binding. You cannot come and collect it from me later because we already have a binding contract. But what I want to buy, if it is defective, then you have breached the terms of our agreement and therefore I can return it. All those kind of things. There is an intention behind every contract. So what was the intention behind this contract? The intention was that the son, that is the husband, should be able to sue to recover the money. It was the intention. It wasn't just expressly stated by mouth. It was expressly written in the contract. This was written and they carried it. The husband now is the plaintiff as be. The husband went to court. He carried the agreement. He showed my lord, look at this contract. Look at what it was written there. That the husband, me, I am the husband, I can sue to collect the money. But then the estate of Usman, that is the other father, who was supposed to give 7 million, said, my lord, whether or not it was written is none of our business. Our business, according to contract law, is whether or not consideration has been furnished. Whether or not it was written is not a concern of this court. What concerns this court was consideration furnished by the husband in relation to that agreement. If consideration was not furnished, then he is not a party. What did the court then hold? The groom's claim was rejected by the court. It was held that the groom was not a party of the agreement between the fathers and he did not provide any consideration for the promise made by the father of the bride. Also, as a stranger to the contract, the son, that is the groom or the husband, could not enforce it. On the basis of this, the court found in favor of the executors of the will, in this case Usman's will. Note that all these things that I'm using is for you to have a better understanding. There is no Usman as the fathers or Taju. It's just for you to have a better understanding. Now, Whiteman J said, some old decisions appear to support the proposition that the stranger to the consideration of a contract may maintain an action upon it. Who is the stranger here? The husband. If he stands in such a near relationship to the party from whom the consideration proceeds, that he may be considered a party to the consideration, but there is no such modern case on which the proposition has been supported. On the contrary, it is now established that no stranger to the consideration can take advantage of a contract, although made for his benefit. What did Tweedle and Atkinson, the judge, say? That's Whiteman J. What did he say? He said, stranger to the consideration. A stranger to a consideration cannot enforce the contract, right? Although in the case of Price and Easton, he said stranger to the contract. Don't worry, in my next class I will give you more detailed explanation where we'll be talking about the doctrine of privity of contract versus the doctrine of consideration. I will give you a more detailed explanation as to this area of stranger to consideration and stranger to contract. Thank you so much for watching to the end of this lecture. Please make sure that you share this video with your friends and any other person that you know would be interested in the video. I will see you in my next class.